welcome again to Florida Appeals Journal. I'm Jennifer Carroll, and we've got an interesting issue today. I'm going to change things up a little bit, and start with the big question, and then that'll relate to a very fundamental case that everyone should have in their library. The question this week: to have a transcript or not to have a transcript? When should you require either yourself or your client to expend funds to pay for a court reporter for a hearing or a trial? It's an issue every litigant encounters. Not that easy a solution either. The basic traditional case on this issue, and everybody knows this, is the Applegate case, and that's 377 Southern 2nd, 1150, Florida Supreme Court, 1979. As a general rule, and this is what the Florida Supreme Court established in Applegate, a very old case at this point, failing to provide a transcript of the lower court's proceedings can be fatal to your appeal, especially applies when there are issues of fact that require the appellate court to draw conclusions about the evidence. So especially when it's an evidentiary matter, you definitely want to have your transcript. Believe what the Supreme Court said in Applegate, and let me just quote because this makes it very clear. When there are issues of fact, the appellant necessarily asks the reviewing court to draw conclusions about the evidence. Without a record of the trial proceedings, the appellate court cannot properly resolve the underlying factual issues so as to conclude that the trial court's judgment is not supported by the evidence or by an alternative theory. Without knowing the factual context, neither can an appellate court reasonably conclude that the trial judge so misconceived the law as to require reversal. The trial court should have been affirmed in the Applegate case because the record brought forward by the appellant is inadequate to demonstrate reversible error. And you always hear you've got to preserve error for appellate review, which means usually you raise an argument in the trial court before you can raise it at the appellate court. But you always have to have a record, and a sufficient record. And what we're talking about today is having a transcript. When is that necessary? But what you have to realize is it's not always fatal if you don't have one. If the appellate court can review other parts of the record, whether it's the pleadings, you may have depositions on file, but especially if there's only a legal issue that's involved in the appeal, you may have an adequate record without a transcript. So don't forget that key principle. And an example is the Northeast case. That's 643 Southern 2nd, 1193. That's a 5th DCA, 1994. There are plenty of cases out there. The 5th District in that case held that the appellate court could review the question of whether there was personal jurisdiction without a hearing transcript, where the trial court's order reflected that it considered the complaint, affidavits, and the applicable case law and argument. And I would refer you also to the Hark v. Pennymack Court case. That's 210 Southern 3rd, 726, Flaw 2nd DCA 2017. And in that case, the 2nd District cites many other cases that state that transcripts are ordinarily not necessary for an appellate court's review of summary judgment. That to me is very interesting. So it depends on what the issues are, certainly in your case. If they're solely legal issues, and you have through legal memoranda or motions, pleadings that are part of the record on appeal and part of the trial court record, that may be sufficient. But usually when you have a trial or an evidentiary hearing and you're trying to challenge something that's going to require the appellate court to review evidence, you're going to need that transcript. You're taking a very big risk, but it's a very tough hurdle to overcome. What you do want to be aware of is there are ways to recreate the record, and a lot of people don't realize this. I'm going to refer you to Rule 9.200, the Florida Rules of Appellate Procedure. If you don't have a trial transcript, you didn't hire a court reporter, there are a couple things you can do, a couple processes that you can follow. And if you look at 9.200, we'll look at the big book here, 9.200 A3, governing the contents of the record. 3 is the parties may prepare a stipulated statement showing how the issues to be presented arose and were decided in the lower tribunal, attaching a copy of the order to be reviewed and as much of the record in the lower tribunal as is necessary to a determination of the issues to be presented. The parties shall advise the clerk of the lower tribunal of their intention to rely on a stipulated statement in lieu of the record as early in advance of filing as possible. The stipulated statement shall be filed by the parties and transmitted to the court by the clerk of the lower tribunal within the time prescribed for transmittal of the record. So that's one way, get a stipulated statement. Again, that can be tough if you don't have cooperative opposing counsel, but it's definitely worth a try. And then you can go to sub 4, actually B sub 4. And here's another way that you can prepare really a statement of the evidence. Quote, if no report of the proceedings was made, or if the transcript is unavailable, a party may prepare a statement of the evidence or proceedings from the best available means, including the party's recollection. The statement shall be served on all other parties who may serve objections or proposed amendments to it within 10 days of service. Thereafter, the statement and any objections or proposed amendments shall be filed with the lower tribunal for settlement and approval. As settled and approved, the statement shall be included by the clerk of the lower tribunal in the record. So you would follow this process. The other side can go ahead and make objections or amendments, and then you're going to have to go and get approval by the trial court. So you'll generally set that down for a hearing yourself and try to get that resolved by the trial court. So there is a way. There are avenues there, and so much depends on the circumstances of your case and how cooperative the other side would be. So this leads me to the courtroom savvy or practice tip of the week and concerning such an issue. When in doubt, always have a court reporter. It doesn't matter how many years you've been doing this, you're always learning. You may think that something is so simple, and I've done this, like you just go into a scheduling hearing, and I had something that occurred where I thought I'm just scheduling this trial coming up, getting a date, and lo and behold, the judge starts raising certain questions and issues, and opposing counsel actually starts making some stipulations on the record. And you normally try to put that in order if you can, and you could try to preserve it that way. But if you don't have a court reporter, it's going to be tough. So definitely you look at the circumstances. But if you do, especially any type of complex litigation, and even the simplest, but usually if it's worth having a hearing, it's worth having a court reporter for the most part. So just keep that in mind. So many permeations that can occur, and it's so hard to have a crystal ball to guess exactly what's going to happen at the simplest hearing. So I strongly recommend have a court reporter if at all possible. That does it for this week. Again, send us any issues that you think are pressing in our legal community that need to be addressed on one of our weeks, and we'll certainly do our best to take a look at it for you. Thank you again, and we'll see you next week. Hi, I'm Jennifer Carroll, and I want to thank you for watching our video. You can see more of our videos right here. Or better yet, subscribe to our YouTube channel below so you won't miss a single one.